May I please, Your Lordship?
Yes.
Yes, with regard to item number 1 of hearing list, which is fixed for today.
It's a fixed matter, actually.
Yes.
Yes.
That the matter may be taken up next week.
Next week.
Yes. On
You are for the appellant?
yes.
Learned
On 12th of May.
On 12th, okay. Learned Counsel, Mr. Such and Such, makes a mention for listing the matter on 12th May, as he has some difficulties today. Stop. Praise the Lord. List on 12/5 as prayed for.
Yes, oblige, Your Lordship.
May I seek your Lordship indulgence in mentioning part 2, item number 3.
Yes.
Lordship, I have taken consent of the other parties if the matter can be kindly taken up after 2 weeks.
You're mentioning on behalf of petitioner?
Yes, Lordship.
Okay. Learned Counsel, Miss Such and Such, appearing for the petitioner, prays for listing the matter after 2 weeks. On what ground?
Since the leading counsel has some personal difficulties.
Okay, since the leading counsel has some difficulties today, so praise the Lord list after 2 weeks. Before that, you just say that it is submitted that the consent of the other party has been obtained. Then list after 2 weeks. Yes.
Duly obliged.
For omission, item number 1.
Yes, all the respondents are represented.
Yes, my lord. In this case, my lord, there is a recent affidavit filed by the respondent number 2, 24/2026 affidavit dated 24/2026.
24.
Yes, my lord. 20th April 2026. And before I address to the stand taken by the respondent, my lord, I would like to refer to one judgment, my lord. This contempt case pertains to non-compliance of the order dated 4/7/2024 in WPC number 66 of 2024. And this WPC number 66 of 2024 was disposed in line with one different judgment, which I may place before your lordship. WPC number 64 of 2023.
On the ground that it was a covered case.
Yes, my lord. Since the present case under the contempt, my lord, there is no detailed elaboration. I have to refer to the previous judgment, my lord. If your lordship may kindly see this WPC number 64 of 2023, and on the third page, my lord, you will find that WPC number 52 of 2022. These two cases were taken up together by this common judgment order dated 6/5/2024. And the issue among others is that all the petitioners, the present case also, my lord, they were appointed as government teachers on regular basis. And prior to their regular appointment to the government, my lord, they have rendered services under the capacity of ad hoc service as well as SSA under CSS. And by the notification dated 2013 and corrigendum 2014, those teachers who have rendered prior service under ad hoc or CSS employees were eligible to count their past service for the purpose of upgradation to senior and selection grade. Provided
Upgradation to?
senior and selection grade.
Okay.
Senior and selection grade. Provided they rendered continued service without break.
As in this, under the CSS and an ad hoc.
Yes, my lord. So, my lord, accordingly, my lord, in this writ petition number 64/2023 by judgment order dated 6/5/2024, which I have just placed before your lordship. I would like to refer
1 minute.
to
Let us see the direction in this case. then.
before that, my lord. I would like to draw your lordship kind attention to para 11. Para 11.
Of the judgment.
Yes, my lord.
Yes.
This is the stand taken by the state respondents, my lord. What I mean to submit here is that, my lord, the same stand which was already overruled by this honorable court was again taken in the contempt proceeding. Para 11, my lord, may I read?
Okay. This provision.
Mrs. So-and-so, learned government advocate, by referring to the affidavit in opposition of the state respondents, more particularly at para number 6 and 20, submits that as per the advertisement floated by the MPSC, those who are in government service should apply through proper channel. The petitioners who were also given no objection certificate by the district education officer to participate in the selection process. But however, the same cannot be the basis to show that the petitioners were in government service prior to their appointment as regular high school and middle school teachers. She submits that the notification dated 19/7/2013 provides for counting of past service rendered on ad hoc deficit without break till regularization for those teachers of newly provincialized teachers schools. This provision is not applicable for directly recruited teachers like the petitioners in the present case, unless their service were provincialized prior to their appointment in the government service. In terms of the advertisement floated by the MPSC, the petitioners not being in government service prior to their direct appointment as government high school teachers and middle school teachers, they have no right to claim of counting of their past service rendered on ad hoc basis. So, my lord, the stand taken by the state respondents in the writ proceeding is that this particular notification 2013 followed by corrigendum 2014. The state respondents, according to them, was that this is applicable not applicable to the case of the petitioners who were appointed to the government on
Directly recruited.
directly recruited, my lord. But, my lord, so far as this notification is concerned, those teachers, regular teachers who have rendered past service under ad hoc or CSS were entitled to count the past service, irrespective of the manner in which they were regularized under the government. And further, my lord, for those who were regularized under departmental regularization, there is different scheme. That is the rules of 2020.
Okay.
For those who were regularized in the same substantive sanction post, rules of 2020 is there. So, my lord,
So what was the direction here? Ultimately, what did the court
para
say?
13, my lord, kindly come to para 13 of the same judgment. 1-3.
Yes.
I have heard the submissions made by the learned counsels for the parties, and I have perused the materials available on record. The issue to be considered is as to whether the petitioners who were initially appointed under the SSA, CSS, or as ad hoc teachers can be given benefit of counting their past service rendered prior to their appointment on regular basis, in terms of notification dated 2013 and corrigendum 2014. And
Initially appointed under the SSA or as a top teachers. Okay.
if you also may kindly see para 16, 1-6. There's a rules of 2020 enacted by the state respondents. And if you also may kindly see last line of the para 16 to cut it short,
Yes.
on the following page, my lord.
Yes.
These rules of 2020 is applicable to those regular appointments to the same substantive sanction post. This is rules of 2020.
Centers and such, and upon their appeal to the same substantive sanction.
So far as the present petitioners were concerned, my lord, since we are not regularized on the same substantive post, sanction post, we are directly recruited. So this notification of 2013 and corrigendum 2014 is applicable in our case. So, my lord, para 18, 1-8.
Upon their regular appointment.
Para 18, 1-8.
Yes.
This is the direction and findings of the learned coordinate bench. Therefore, upon due consideration of the case in its entirety, I move the considered view that the petitioners are entitled to be considered for counting
Of the past
their
service.
past service rendered prior to their regular appointment in terms of notification 2013 and 14. Accordingly, the respondents are directed to process the case of the petitioners for counting their services rendered under ad hoc or CSS for their placement to senior selection grade in terms of the notification such and such. In doing so, the respondent authorities concerned will be at liberty to verify and scrutinize the service particular of the petitioners. My lord, this particular point is now misinterpreted by the state respondents. The respondent authorities concerned will be at liberty to verify and scrutinize the service particulars of all the petitioners. The intention of this particular order is that, my lord, what they have to scrutinize and verify is that whether they have rendered continued service from their past ad hoc or CSS followed by regularization. Only that point, my lord. And in all the cases, my lord, we have enclosed certificate issued by the concerned authority to certify that they have rendered continuous service. And this WPC number 64 of 2023 and WPC number 52, which I'm referring, my lord, the one I'm referring right now, order dated 6/5/2024. One of the judgment is already complied with by the respondents. And I have enclosed the compliance order in my contempt petition. And now coming to the present case under judgment under contempt, my lord. Before I come to that, my lord.
1 minute. Let's see this order dated 4/7/24, WP 66. What does it say?
Page number 16 onwards, the relevant portion is in page number 23 of the contempt petition, my lord. Para 6, my lord.
So you were also, the petitioners here were also were serving under the SSA.
Yes, my lord. Before that, my lord,
And-
to clarify this point, para 4, if I may take a lordship to para 4 onwards, para 4, page number 22, para 4.
Yes, yes.
May I read? The learned counsel for the petitioners, Mr. So-and-so, has also drawn the attention of this court to the common judgment order dated 6/5/2024, passed by this court in the WPC number, by which the service of the petitioners therein rendered under the CSS and on ad hoc basis, followed by their regularization as government teachers, was directed to be considered in terms of the notification dated 2013 and corrigendum 2014. The learned counsel submits that the case of the instant petitioners are also similar, and they are squarely covered by the said judgment and order. Mr. So-and-so, learned additional AG, submits that prima facie, it appears that the case of the petitioners may also be covered by the judgment and order under reference under notification and corrigendum, as reflected herein above. But, however, the respondents may be given liberty to verify and examine the claim of each of the petitioners to find out as to whether they are eligible to be given the benefit of counting their past service in terms of notification and corrigendum so-and-so. Upon hearing the learned counsels for the rival parties and upon perusal of the materials available on record, this court does not find any impediment in disposing of the writ petition. The respondents are accordingly directed to consider the case of the petitioners for counting of their services rendered under SSA, CSS, for the placement to senior citizen grade in terms of the notification and corrigendum. In doing so, the respondent authorities concerned will be at liberty to verify and scrutinize the service particulars of the petitioners. This is the direction, my lord.
Okay, okay.
And my lord,
So what has happened now? They have not considered your case. Nothing is being done.
my lord, I'll come to that, my lord. Well, there are also 3-4 cases similar nature, my lord. So far as the first judgment which I'm referring, I have enclosed the compliance order in my contempt petition. And my lord, thereafter there's some confusion or misinterpretation, whichever the said respondents may interpret it, that which part of the service particulars are they supposed to verify or scrutinize. So far as the eligibility of notification 2013 and corrigendum 14 are concerned, it is no longer res integra, that they are eligible to be enjoy the benefits of the notification. But the only thing which they have supposed to verify and scrutinize is whether they have rendered continued service from their past service.
Right, right. Because
Accordingly, my lord-
since the case was disposed at the motion stage,
Yes, my lord.
so it was only proper that they would be given time to scrutinize.
Yes, my lord.
That is okay.
Yes, my lord.
So now they were given three months time.
Yes, my lord.
3
So,
months
my
time.
lord.
So within that time, what have they done?
Yes, my lord. Your Lordship may kindly come to.
Because if there is substantial compliance also, then contempt will not lie.
My lord, they have.
It-
Now, my lord, coming to the affidavit filed by the respondents, more particularly respondent number 2, which was filed on 9/12/2025. 9/12/2025
Respondent
by
number
respondent number 2.
2.
He is the secretary to the school education department. Have you got it, my lord?
Yes.
I'll come straight to the annexure, running page number 6 of the state affidavit. Your Lordship may kindly keep in mind that so far as for those who were regularized from in the same sanction post, substantive sanction post, the rules of 2020 is applicable to them. But so far, the present petitioners who were appointed on direct recruitment, we are claiming the benefits of 2013 notification and original 2014. Now coming to the order dated 1st May 2025. Whereas judgment order dated 4/7/2024 was passed by the Honorable Court in the PC number 66/2024, giving the state respondents liberty to verify and scrutinize the service particulars of all the petitioners. And whereas contempt petition number so and so in connection with judgment order dated 4/7/2024 was filed by the petitioners. And whereas the service of the petitioners were scrutinized and examined as per the liberty given by the judgment order dated 4/7/2024 in the BPC number 66 of 2024. And whereas the government have in the past made an error of granting the counting of past service on similar case. Such errors made by the government regarding counting of past service should not be interpreted as a precedent to justify future similar case. Now, therefore, past service for direct recruit under the government of Mizoram may be read as the government, after careful consideration of all the facts and circumstances, and upon exercising the provisions of Clause 3 of the Mizoram Government Employees Rules 2020, notification dated 2013 and 14 cannot entertain the petitioner's claim of counting of past service, as the said rule and notification do not entail provisions of counting of past service for direct recruit under the government of Mizoram. The interpretation and the law in this regard, my lord, it is no longer res integra, as already held by the first judgment. And my lord, moreover, there are other previous several judgments also, my lord, which was also referred in the first judgment which I had referred, since back in 2018 onwards.
No, see, Learned Counsel, I understand what you're trying to say.
Yes, madam.
But para 6 of the judgment, it says to consider the case of the petitioners. So they have considered and they have come out with this notification. So now you have to challenge this in a new, fresh, this is a new cause of action, which is a reason. So now you have to challenge this. In a contempt jurisdiction is very limited. So in a contempt petition, we cannot go into all these new notifications which have come up. So at best, this court in the contempt can only say that the petitioners, the direction of this court to consider has been done. That consideration part has been done, and they have found that you are not eligible, and they have issued this order. So now this order has to be challenged.
My lord, my humble
But in
submission
this
is that
contempt petition,
I
there is
understand
nothing
that
much
under
we
the
can-
contempt jurisdiction, it is limited that whether the state respondents had complied with the judgment or not.
yes.
But
So
now,
we can say that the court's direction was to consider. So that process of consideration has been done by the government. So consideration can be two ways: consideration favorably and unfavorably. So they have considered and found that you are not eligible. So now you can always assail this, saying that similarly situated persons have already been granted this.
that is the same stand taken in the writ proceeding, my lord. In the first judgment which I had referred, my lord, the stand of the respondents was that this notification is not applicable to these petitioners who are similarly situated.
Who's
But-
appearing for the respondents?
But that was already overruled, my lord. And the present case, WPC 66, was disposed of in line with the
Of
earlier
course,
judgment, my lord.
Of course, maybe a writ appeal.
The same
also could-
findings, will it be appropriate to approach the writ court by bringing benefits and relief which was already granted in the first order? It was already settled by the judgment coordinate bench in judgment order, the 6/5/2024, my lord. The grounds of the rejection of the present case was already taken in the first case, my lord, which was already overruled by this honorable court. In fact, my lord, this amounts to flagrant violation of this honorable court without filing any appeal or review. The referred case, the referred judgment, which on this present case, the other judgment was already complied with by the state respondents, my lord.
Similarly situated. They are all
Similarly situated, my lord.
situated.
The annexure
Then
which I
in that
have
case-
shown you, my lord, similarly situated. Moreover, even without interference of the honorable court,
Then
my lord.
let them appear in person and explain.
Yes, my lord.
Your Lordship,
Yes.
if I may.
Because no appeal has also been filed. No
Your
appeal,
Lordship,
no review.
it's not required because let me, with Your Lordship permission, let me get the facts clear. My learned friend is confusing the court. In as much as my learned friend have relied on, have given the
That previous
the
judgment.
previous judgment. Now, if we see the judgment of the concerned case clearly, may I read, Your Lordship?
The first one.
The case wherein this contempt
No, the
case
present
has
one.
arisen.
Yes, yes.
This is WPC 66 of
66.
2024. The judgment in order is 4/7/2024.
Yes, 4724.
Yes. Paragraph one I will not read. From paragraph number 2, the facts. This is just a facts which is narrated by my learned friend when the case was presented. And the facts of the case as projected by the petitioners in brief is that petitioner number 1 to 45 were appointed as primary school teachers under SSA, which is a CSS between the year 2005 to 2016. As for the petitioner 46, she was appointed under the same scheme but as a middle school teacher. The services of the petitioners were followed by a regular appointment as government primary school and middle school teachers between so and so. Subsequently, their service has been confirmed between years 2017 to 2022. And again, this is a statement made by the petitioners. According to the petitioners, the state respondents in the school education department came up with notification dated so and so by which eligibility criteria to pay upgradation of school, primary school, middle schools and high school teachers in the senior and selection grade was laid down with effect from dated 1/6/2012 as per clause 1 subclause B of the notification. For the purpose of counting the 8 years service in the entry grade, services rendered in ad hoc service continued by regularization into government service without any break shall be counted as qualifying service. The notification dated so and so, corrigendum dated so and so, which besides the service rendered in ad hoc deficit, the service rendered in CSS continued by regularization. The word regularization has to be, yes, stressed upon. Come up to incorporated. Therefore, in the case of petitioners, that they are eligible to count their service rendered by them under SSA for their pay upgradation. The service particulars of the petitioners have been indicated in the form of a chart in paragraph number 7 of the petition. And paragraph number 4, the learned counsel for the petitioner also drawn attention of the common judgment and order dated so and so, by which the service of the petitioners therein rendered under CCS and ad hoc basis, followed by their regularization as government teachers, were directed to be considered in terms of so and so. The learned counsel submits the case of the instant. So whatever I am reading is the submission of my learned friend when the case was presented before the single bench. And in paragraph number 5, Mr. So-and-so, Mizoram submits the prima facie case. It appears that the case of petitioners may also be covered under the judgment and order under reference and the notification so and so as reflected herein above. But however, the state respondents may be given liberty to verify and examine the claim of each of the petitioners to find out as to whether they are eligible to be given the benefit of counting of their past services in terms of the notification dated so and so. Now, this is the decision of the court. Paragraph number 6. Upon hearing of the learned counsels and the rival parties and upon perusal of the materials available on record, this court does not find any impediment in disposing the instant writ petition, that is at the motion stage. The respondents are accordingly directed to consider, not directed to count the petitioners for counting their services rendered so and so. It's the word consider is
No,
there.
that's why I said consider.
Yes, correct. And Your Lordship, now coming to the whole I will just read out the whole paragraph. The respondents are accordingly directed to consider the case of the petitions for counting of their past services rendered under SSS, CSS for their placement in the senior and selection grade in terms of notification dated so and so. In doing so, the authorities concerned will be at liberty to verify and scrutinize the services and the particulars of all the petitioners. The entire exercise should be carried out within so and so period. Now, Your Lordship, what my learned friend is trying to say is that this instant writ petition was disposed in line with those previous two
Yes.
judgments, but it is not, because it is not mentioned that it is disposed in line with that so and so. It just says that to consider the case of the petitioners and to scrutinize their documents if so required.
No, but one question again is, are they similarly situated with the other petitioners?
No,
in the
Your
other-
Lordship, the two judgments.
Because the government has already complied.
Complied
others
with,
too.
and it was a common judgment. Two cases were clubbed together. We have complied with one because that is they are duly covered within the notification as stipulated here. But then we are challenging by way of writ appeal the other case. The other case, common judgment in order, we have complied the one case.
Against this WP 53.
Yes, correct. But now we should not concern ourselves with those two judgments, because here in this case,
No, but if they are similarly situated, then
they are not similarly. They are similarly situated with the case which we are challenging.
this WP 53.
Yes, because they are in the other one. They are regularized. They are absorbed into service. But then the petitioner here and the case wherein we have challenged, they are direct recruitees. Yes, of course, they
That
have
is not correct, my
rendered.
lord. All the petitioners referred in the two judgments, the earlier one was also directly recruited.
Yeah, but we have segregated. We have make some separation, because those
On what
petitioners.
criteria? On what criteria?
On a criteria that the petitioners herein are direct recruitees from the, of
Okay.
course they have rendered their past service in the SSA, but then it was for recruitment of a direct recruitment not notified. It was they have appeared and they successfully they turned out to be a successful candidates. So the notification
Then
as I have,
WP 53 also,
yes,
same.
in paragraph number 3 also the notification clearly said that continued by regularization into service. Regularization, coming back to paragraph number 3, it says that continued by regularization into government service. It says regularization. They were not regularized.
Continued by regularization.
So that is how we make the difference, how we differentiate. So the notification itself is very clear.
So
But-
one group would be the group in WP 64 and others.
Yes.
They are not direct recruits.
In Milton, the other case in which we have filed an appeal is Milton. The case number is 64 of 2000.
No, 64
Of
2024,
2023.
53 of 24.
Yes. In that case also, they are. I have the judgment, Your Lordship.
53 of 2024. Yes, the judgment is here.
Okay.
WP
okay.
53 of 2024, dated 5/8/24.
6/5/24.
5/8 or 6/8? It's 5/8.
Your Lordship, in paragraph number 4 of Milton's case, that is WPC 64 of 2023, it is written clearly for filling up of, it's order dated 6/5/2024.
My lord, this 53 of 2024 is different case. Now, the first judgment which we are referring is WPC number 64 of
No, you have filed appeal against which one?
This case. This
64?
Case. 64, yes. 64 of 2023.
Delay is yet to be condoned in that case.
Yes, delay is yet to be condoned in this case, but I am pointing out, as my learned friend has pointed out, because it was a common judgment in order dated 6/5/2024, wherein WPC 64 of 2023 and 52 of 2022 was disposed of in the same common judgment in order. We have complied with 52 of 2022, but then we are challenging the 64 of
You're challenging
2023
64 of
on
23.
the grounds I have mentioned. Because we can see it clearly as the facts as projected by the petitioners that they have appeared in the advertisement that it was issued by the MPSC on 6/1/11 through the advertisement so and so, and then they were appointed accordingly.
Selection process.
And in our case also, Your Lordship,
MPC. Okay. So the two groups.
There are two groups.
So one group is those who appeared in the selection process.
Yes, in the direct
Through the
recruitment
NPSC.
selection process through MPSC.
So for them, the benefit will not be extended.
That is what we are trying to project, and now we are filing the WA. Yes.
And WA number is?
WA number is. Your Lordship, I do not have the WA number at hand. I can produce it later on. WA number kalau kosong.
Anyway, you
Yes,
just supply
yes.
that later.
Yes, Your Lordship.
Then one group is those petitioners who appeared in pursuance of the advertisement
Yes,
by
yes.
the NPSC, and then they appeared. Then another group would be those who are regularized.
Yes, regularized. And Your Lordship,
Those who were regularized after serving on at either ad
as an
hoc
ad hoc
or under that
or
CSS.
SSA, yes. Your Lordship, that is our case, but that is with regards to WPC number 64 and 52. Now, in our case at hand, whatever was written in the order was just the submission of my learned friend. Now, in paragraph number 6, nothing is mentioned that this petition is disposed of in line with that of 62 or 52 or 64 of 2023.
Okay, understood.
But then it just says that supposing if it says that I could have understand if it says that accordingly directed to consider the case of the petitioners by considering the common judgment and order dated so and so, but then nothing is there. So it is very clear at the motion stage what the single bench have said that to consider the case of the petitioner for counting of their
because at the motion stage, all the materials are not before the court.
Yes, correct.
So
correct.
obviously the court has asked the respondents to verify first and then consider.
Yes.
So now that is understood. Then another ground which you are taking would be that the petitioners here are similarly situated with those of petitioners in WP 64, and in 64 you have preferred a writ appeal. So if the writ appeal is successful, that would automatically cover the petitioners here also. Is that it?
No, Your Lordship, in my humble opinion, in my interpretation, this is totally a different case. It just says that to consider the case of the petitioner.
Petitioner says that he is covered by this WP 64.
Yes. But then we said that the case of the petitioner herein is similar with that of the 64 of 2023. And that is why in our corrigendum as well as the order that we have issued, which my learned friend have already read out,
Okay.
that we have already considered their case, but then they are not eligible for consideration for counting of their past service. And that is why, Your Lordship, coming to contempt section 2 subclause B, it says...
This court, I'm giving you an option. I will either dismiss this petition, saying that the only consideration direction was given, and the respondents have considered and found that you are not eligible. So you are at liberty to challenge whatever subsequent order has been passed. Or in the alternative, we can say that the writ appeal has been preferred against this judgment in WP 64, and therefore to keep this petition pending till the disposal of that writ appeal.
Before I answer to your option offered, my lord, I would like to raise one point. So far as the eligibility of the petitioners who had rendered prior service in the capacity of CSS or ad hoc are concerned, and subsequently followed by the direct recruitment. The coordinate bench of this court had already held that they are eligible to enjoy the benefits of notification 2013-14.
No, Mr. Counsel.
My lord,
Yes.
my only submission is that from which line they are drawing the difference of the previous petitioners in the present
That will
one.
be make out
Because,
in the
my lord,
writ appeal.
both the petitioners, the present one and the previous one, they had rendered CSS past
See,
service.
one problem is when the petition was disposed of at the motion stage, the court did not have the opportunity to go into all the documents.
I understand, my
Yes,
lord.
the court did not know. So that's why the court gave the direction to verify and to scrutinize. So after verifying and scrutinizing, if they've come out with this corrigendum, then
Lord.
then what can one can do?
What I mean to say is that under the first judgment which I'm referring, the learned coordinate bench of this court had held that those who had rendered past service under CSS or ad hoc, followed by direct recruitment, were eligible to enjoy the benefits of 2013 and 14.
So they have filed an appeal against that.
That is yet to be considered, my lord. And the notification 2013, my lord, which we have not pointed out elaborately, my lord, what it says is that those who were regularized and having prior service under ad hoc / or CSS are eligible to enjoy the benefits. So those two judgments, my lord, those two cases which were disposed by the common judgment, my lord, there were two sides of the coin. At one hand, they have complied. The other case, there are two sides of the coin. It cannot be
So
segregated in
they
any
are
way.
saying that the case where they have complied is different from your case.
No, my lord. They are similar in the sense that WPC number 64, 52, and the present case, all of them were rendered services under, they had passed service under CSS or either CSS or ad hoc.
No, one group is those who were serving and then regularized
My lord,
subsequently.
the submission of my friend is not correct. That is what I'm trying to say. Because it's all written there. If I may be allowed to read the first judgment line by line, my lord, it's all written there. They're exactly similar,
see,
my lord.
for that, how does this court know unless
Yes,
all
this is
those
a contempt
documents
court
are
wherein
there?
the merits cannot be
This is a contempt proceeding, and how can we go into all those past records? Those are not before the court.
My lord, for that purpose, what I mean to say is that it is no longer.
And that we only go by the direction. So what direction is there? That is to consider and to verify and scrutinize and to consider. So they have considered, and now they are finding that you are not eligible.
On the grounds of what, my lord? That is the most important thing. On the
Your
grounds
Lordship,
of,
if they
on the
have
grounds of-
questions on what ground, then they can file an
My lord, my
appeal
lord.
against that order.
No, in
The
this
grounds-
petition we cannot go
My,
into.
my lord,
Yes.
my humble submission is that the grounds which they have taken for rejection of my case is already settled by this honorable court in the first judgment.
If so,
so
let
this
them file
amounts
the
to
appeal.
flagrant violation of this honorable court, my lord.
So they have filed an appeal against that.
No, my lord. That's,
So we cannot say that it's settled now. Who
The other-
knows?
the other- the
Who
other
knows?
case
It
was
may
already
be.
complied
Who
with,
knows?
my
It
lord.
may be reversed.
the other case was already complied with, my lord.
That's why they're saying this is different. The other case where they have complied
What I'm
is
saying is that,
different.
my lord, my humble submission
So
is that,
let the court decide in the appeal finally.
my lord, what I mean to
Yes.
say is that they are not different. That if you allow me, I can see only
That
one
is
page,
your
only one page, my
submission.
lord.
You are saying that they are not different. They are saying
My
that
lord,
you are
My
different.
lord, only one point for the last submission, my lord.
Yes,
Page number 10 of the affidavit dated 28th April 2026.
page 10. Yes.
Page number 10. Finally, see the last line, the second last line.
Yes.
Corrigendum dated 27/3/2026. The petitioner's claim of counting of past service cannot be entertained as the said rule do not entail counting of past service for direct recruit under the government of Mizoram. What I mean to say is that, my lord, this notification is applicable to those direct recruitee. That is already settled, my lord.
So they are saying that you are also direct recruit.
Yes, my lord, correct. So all the petitioners in the previous case were also direct recruit.
No, your ground is that they have been regularized later, isn't it? Not
lord.
direct recruit.
My lord, the manner in which we are appointed having past service were exactly similar, and we all are recruited in direct basis. On
No,
direct
there
basis.
is a slight difference because they are saying that the petitioners in the other case where they have complied,
No. That is totally wrong. That is
they
what
were
I'm trying to point out, my lord.
regularized. They were regularized.
That is not correct.
Whereas you appeared in pursuance of an advertisement.
My lord, if I may be allowed
Your
to refer
Lordship,
again the
nevertheless,
first judgment.
rightly or wrongly, it was disposed of. It was considered. Then the judgment is already complied with.
When it may be either considered or rejected, my lord, my case, but the manner in which they have considered my case, if it amounts to contempt of court, and if it is in violation of the standing order, which was
No,
Your
there
Lordship,
is
yes,
no
your
contempt. There
jurisdiction.
is no contempt. Third learned counsel for the petitioner, Mr. Victor Aruralte. Stop. Also heard learned counsel, Miss Mary L. Kiangte for respondent number.
All the respondents, Your Lordship.
Otherwise, my lord,
All the respondents.
as your lordship had already mentioned, my lord, it may by the outcome of the writ appeal which they have preferring today.
That's why I gave you the two options. I said I'll either
It may keep in
dismiss,
abeyance.
I'll either
It may
dismiss
keep
it
in abeyance
or
until
keep it
disposal.
pending till the disposal of that writ appeal. Okay, what did I say? Sir, also sir and such. Stop. Upon going through the records and on hearing the submission of the learned counsel for the parties, it is seen that the state respondents it has been informed that the state respondents have filed a writ appeal
17 of 2025, but
17 of 25.
17 of 25, but condemnation is yet to be delayed and application is filed by way of I-8230 of 2025.
It's okay, we'll just say 17 of 25. Yeah. That the state respondents in WP 64 of 23 have filed an appeal which is registered as WA 17 of 2025, and an IA has also been filed along with the writ appeal for condonation of delay. So accordingly, this court is of the view that if the division bench reverses the judgment in WP 64 of 2023, the same would have an effect on the present petition. Accordingly, this petition after the disposal of WA 17 of 2025. Okay.
Highly obliged.
Item number 2.
Now, my lord,
Same.
on the same issue, but my lord, on the first case, my lord, there are two cases disposed by common judgment order. The previous council has submitted that they have preferred appeal in one case,
Yes.
but in other case that has been complied with. And the present case in item number 2, they were similarly situated in all respect with the judgment which was already complied. The other part of the writ petition.
That 53.
Yes, madam.
Just give me those judgments.
From the WPC number 64,
The judgments which are given, no?
the WPC number is, my lord,
This one and this one.
52. If you also may kindly see the WPC number 64 of 2023, on the third page, my lord, WPC number 64, 2020, on the third page.
52.
WPC number 52,
52
2022.
of 2022.
Exactly similar.
Oh, 22 they have already complied.
Yes, my lord. If you also may kindly see, I have also enclosed in the previous case, my lord, the compliance order. It was already complied. Both
Then in their reply here, what do they say?
Oh, the same ground, my lord.
Same.
Yes, my lord, the same ground. That they are not entitled to so and so. The conduct, the manner in which they are taking up my case, my lord, this is amounting to flagrant violation of this noble code, my lord.
Yes, Learned Counsel, are they similarly situated with those in WP 52?
Your Lordship, on that regard, I will have to seek further instructions because again this is a contempt. So I was only instructed on as to whether the order was complied to or not. Order 52 of 2020, whether the instructions and compliance was done as per the directions in 53 2024, Your Lordship. As to whether they are similarly situated or not, Your Lordship, I will have to be apprised by the concerned department.
Where is the impugned order in this one? I mean the order to be
My lord,
complied with in
it's
this
from page number 12, 11.
page
Disparity
12.
for portion is in page number 13, 1-3.
Para 6.
Yes, my lord, para 6.
Impediment, just according to- Here also same thing. that
Same thing, my lord.
To
And
consider granting the
my lord,
benefit.
coming to the last line of para 6, my
It is
lord,
also
page number,
furthermore
bottom of the page.
Will be at liberty to examine and scrutinize the claim made by the petitioners that they have been working since the initial. Will be at liberty to examine and scrutinize the claim. Within the term limit of 3 minutes.
Your Lordship may kindly notice that in the middle of the paragraph 6, my Lord, the direction for the manner in which they were supposed to. they
This
were
one
given
also
liberty.
was disposed at motion stage.
Yes, my Lord. But my Lord, if Your Lordship may kindly see the middle of the paragraph, which states that it is also provided herein that while considering the case of the petitioners, the respondents will be at liberty to examine and scrutinize the claim made by the petitioners that they have been working since their initial appointment on ad hoc basis without any break in service. Because, my Lord, the only thing which is required to be examined is whether they have continuing service from their past service till their regularization. That is the only point which they are supposed to verify. In all the cases, my Lord. Because the eligibility otherwise under the notification to the party.
And no appeal has been filed in
No
WP
appeal has been
52.
filed, my Lord, because the referred judgment was already complied with. But now they have taken the same stand, the same old stand which was already rejected by the learned single judge coordinate bench of this court.
See, learned counsel, they have to make a clear stand.
Yes, Your
Okay.
Lordship.
Certain people who are similarly situated, they have already complied, those who were in WP 52, that is their allegation. Whereas these petitioners, their cases have been rejected. So unless a clear stand is taken, this court will not be able to find out whether any contempt has been committed or not. Okay. But here also, I think it is only for consideration.
Yes, Your Lordship. Now, Your Lordship, my
To consider.
The eligibility otherwise is already settled, my Lord, by this court. The only thing which has to be looked into is that whether they have continuing service from their past service followed by regularization. If there is any break, then their case can be rejected. But if it is followed without break,
It is needless to state herein that if the petitioners are found to have continued in the service, they shall be granted the benefit of the rule without delay. Yes. So what if you said in your affidavit that if the petitioners are found to have continued in service?
Continued?
Yes, that is the main criteria.
in all the cases, my Lord, even in the previous case, my Lord,
No, but there the initial recruitment, the
we are exactly saying,
requisition.
my Lord, we are exactly saying.
No, anyway, there they have filed an appeal, so we'll see. Okay, so you clarify this point.
Moreover, my
We'll
Lord,
Your
give you
Lordship.
1 week's time. You
Your
clarify
Lordship.
this point. Okay,
Your
so
Lordship may
Yes.
kindly refer to the previous order from 1st April 2026. I'm sorry, from 10 to 2026.
10 to
10 to 2026.
such and such
Sixteen
joint
point seven.
affidavit. However, this is contempt envelope to file individual affidavits by each of the condemners. Have they filed individual affidavits?
Your Lordship, on that regard, there has been an honest irregularity on the part of the department. I had sent 2 copies for signing the 2 copies of the affidavit in compliance, and they had unfortunately returned only 1 copy, Lordship. So in that regard, Your Lordship, a special messenger will be sent tomorrow, and the same will be signed and returned by the department. And also, Your Lordship, as to the clarification sought by this court, that also will at least take at least a week's time, Your
That
Lordship.
also you get, even if it's verbal clarification.
Yes, Your Lordship.
Or file it by way of affidavit. I think that's better, so that we get it in written.
That means, Your Lordship, I'll be filing it in the affidavit in compliance in this contempt.
No, or a written instruction.
Yes, Your Lordship,
instruction.
that can be
My
had.
Lord, my Lord.
Your Lordship, if the query may be reflected in the order as well.
Yeah, we'll do
My
that.
Lord,
Yes.
let it be on by way of affidavit, my Lord. The submission they have made is that letter of compliance, but they have rejected in other case.
No. What I'm saying is, today I'll just give them time to get a written instruction regarding that similarity. Okay. The response is ready to be filed while the affidavits are waited. Joint affidavit has been filed. Okay. Heard learned counsel for the petitioner, Mr. Such and Such. Also heard Miss Lal Non Lui, learned counsel for the respondents, who submits that the affidavit on behalf of respondent number. So whose affidavit is awaited?
Your Lordship, all the state respondents, 1 to 5.
All the contenders.
Okay. that the separate affidavits on behalf of all the respondents have to be filed, and that she may be given 1 week's time to file the same. Stop. Para. Upon going through the records, this court has also seen that there is a direction by this court in order dated 5/8/2024 that if the petitioners are found to have continued in their service, they shall be granted the benefit of the provisions of the notification dated 19/7/2013 without delay. Stop. It is the submission of the learned counsel for the petitioner that the present petitioners are similarly situated with the petitioners in WPC 52 of 2022. Stop. And the respondents have not preferred any appeal or review against the judgment and order in WP 52 of 2022, and in fact the state respondents have complied, is it?
Yes,
have
my lord.
complied with the directions in respect with the directions of this court in WPC 52 of 2022 by granting the benefit of the notification dated 19/7/2013 to the petitioners in WP 52 of 22. Stop. The learned counsel for the respondent shall therefore get written instructions on the next date as to whether the petitioners herein are similarly situated to the petitioners in WP 52 of 2022 and the reasons why the petitioners in the present petition should not be given the similar benefit. Stop. Okay. List after 1 week.
Much obliged, Your Lordship.
Deeply obliged.
Item number 3.
Yes, Your Lordship, I'm representing the state respondent. Even though, Your Lordship, today the matter is fixed for admission hearing, I seek 2 more weeks, Your Lordship.
2 more weeks.
Yes, and I have taken the consent of the parties.
Learned Government Advocate Ms. Vani Swami prays for 2 weeks to... You have filed your affidavit?
Yes,
Yes.
reading is complete.
Okay. 2 weeks for admission hearing. So, learned counsel for the petitioner is present and has no objections. List after 2 weeks for admission hearing.
Deeply obliged.
Item number 5.
This is for...
I'm for respondent number 6.
No, wait.
Then
This
I
is
will
item? This is item 5.
5,
Okay,
yeah.
okay.
5 yes, 4.
Then what happened to 4?
4 to 0, 5
Did you call out item 4?
Sorry, item number 4.
Yes.
May it please your lordship. My lord, this writ petition is filed under section 528. This criminal petition is filed under section 528 of BNSS
Okay.
2023 against the respondents. That the FIR number 1623, dated 14/9/2023 under section 24(1) B of Immigration Act 1983. Arising out of suo motu number 45 of 2022, dated 3/8/2023, was illegally filed against the petitioners. And my lord, my contention is that this is a summons case. The punishment is only 2
Up to
years
2 years.
imprisonment and a fine of 2,000 rupees. And since at the time of we have filed this criminal petition in the month of 30th March 2026. At the time of filing of this criminal petition, since charge sheet was not submitted, and my
Case diary is there?
Yes, Your Lordship, I have received the case
Okay.
diary.
Yes.
And my lord, the brief facts is that section 24(1)(b) of Immigration Act is that
Do you have the Immigration Act?
Immigration Act section 24 subsection 1(b).
Immigration Act 1983. Yes, yes, continue.
Yes. And my lord, section 24(1)(b) says that contravenes the provisions of section 10 or section 16. So if we go to section 10 and section 16, section 10 says about that no person to function as recruiting agent without a valid certificate. And section 16 says about that.
No, Immigration Act. Immigration Act.
Section 16 says about that recruitment by employers to be through recruiting agent or under permit. So in this case, my lord, we never employ these women outside India, but we employ within India because the district magistrate also issued a valid certificate to us. Under section 5, and those relating to my license, my valid licenses are put as Annexure 1, starting from page number 23. And those are my valid certificate, which were issued by district magistrate under section 5 of the Private Placement Agencies Act 2015, Mizoram Private Placement Agencies Regulation Act 2015. But my lord, my grievous contention is that if we go to section 187 of BNSS, subsection 9, BNSS, section 187, subsection 9.
BNSS also, and then Immigration Act also. BNSS section
187, subsection 9.
Yes.
BNSS section 187, subsection 9. It says that if in any case triable by a magistrate as a summons case, the investigation is not concluded within a period of 6 months from the date on which the accused was arrested, the magistrate shall make an order stopping further investigation into the offense, unless the officer making the investigation satisfies the magistrate that for special reasons and in the interest of justice, the continuation of the investigation beyond the period of 6 months is necessary. Since no clarification and no prayer was made by the investigating officer before the landed magistrate court. So this greatly violates
So investigation is still going on.
Yes, my lord, till at the time of still filing this criminal petition.
Your Lordship, if I may, now charge sheet has been submitted
When?
this month, on 4th.
Acha. Okay, that is one of the grounds.
That means, my lord, the charge sheet was filed after filing of this petition. And then, my lord, this on
This petition was filed on
30th March 2026.
30th March
2026.
2026.
And since there is a delay of 2 years and 6 months,
2 years.
and 6 months, my lord.
Charge sheet filed when?
4th May 2026.
Only after this petition was filed, it was submitted. That means, acha. Then,
And then, my lord, this honorable court, in the year 1987, that is State of Tripura versus Sri Nigaranjit Singha and another. Here is May I take you to my Lord?
One minute, okay. The Immigration Act, what were you referring to? Which section in
Section
immigration?
24, subsection 1B. That was the charge offense.
24,
Punishment was 2 years.
24,
1B.
1B. Contravenes the provisions of section 10 or section 16. Okay, so it has to be only through a recruiting agency with a certificate and with permit.
Yes.
So your contention is that you have a valid certificate as well as permit.
That was issued by district magistrate. And that certificate was issued under Section 5 of the Mizoram Private Placement Agencies Regulation Act 2015.
Okay. That is one ground. Then the other ground is that charge sheet was not submitted even after 2 years, 6 months.
Yes, my lord.
Yes.
There is a delay of 2 years and 6 months.
Let's see. Yes, State of Tripura.
Yes, my lord. Page number 11. Page number 11, para number 12, starting from para number 12. And here also, this is a summons case, a summons offense. And my lord, I would like to mention is that Section 187 BNSS is similar with
Equivalent to
Section 167 CRPC. No even single word was changed. It is similar. So, para number 12, in my opinion, the mandate of the legislature in respect of subsection 5 of Section 167 CRPC is clear, and in cases triable under summons procedure, the investigating agency must complete the investigation within a period of 6 months from the date of arrest of the accused, failing which the magistrate is legally bound to stop further investigation. If the investigating agency wants to proceed beyond the period of 6 months, it must make an application before the court within the aforesaid period, and the court may allow, after applying its judicial mind, continuance of investigation beyond the above period, provided the court is satisfied that there are special reasons and that for ends of justice, such continuance of investigation is necessary. Any other interpretation, in my opinion, will make the provision nugatory, and it will go contrary to the intention of the legislature. In my opinion, in any case triable by a magistrate as a summons case, the requirement of subsection 5 of Section 167 must be fulfilled before the magistrate can take cognizance. I hope and trust that both the trial courts and the investigating agency will scrupulously follow the mandate of the legislature as laid down in the above provision of law. And in para number 13, my lord, in view of the above opinion, I respectfully accept the law laid down by the Calcutta and Rajasthan High Courts, but disagree with the views expressed by the Madras and Delhi High Courts, as in my opinion, the question of miscarriage of justice may not arise, as the entire proceeding will be illegal in view of the violation of the provisions of subsection 5 of Section 167 CRPC. Coming back to case in hand, it is an admitted fact that the charge sheet was submitted after 6 months of the arrest of the accused persons. There is nothing on record to show that any prayer was made by the investigating agency for extending the period of investigation. The prosecution also did not take recourse to subsection 5 of Section 167 CRPC. In view of the above circumstances and what has been stated above regarding the interpretation of subsection 5 of Section 167 CRPC, I am of the opinion that the order dated 10/12/84 was legally and validly passed by the learned Chief Judicial Magistrate, and it need not be interfered with. My lord, here also it says very clear that it is mandatory, and since Section 167 is similar with Section 187 of BNSS. Since our case is a summons case, and the investigating agency did not make any prayer before the magistrate court, So it has to be, the FIR has to be closed, and or even the criminal, this proceeding has to be closed. That is my prayer, my lord.
No, this judgment indicates that there are contradictory state judgments by various high courts. He has referred to West Bengal and Rajasthan, Madras, Delhi. So is there any Supreme Court interpretation of the matter? What is this? Assam, Guwahati High Court. The other case.
Yes, my lord. Okay.
Let's see.
And
Which is the relevant para in this Guwahati High Court judgment?
para number 12, my lord, para number 12 and para number 13. And here is, my lord, Supreme Court also says that investigation cannot go endlessly, cannot go too long. And since the investigation agency has to make a clarification, explanation regarding the delay. So here is the Supreme Court judgment, my lord. My lord, this is a case about that Robat Lal Chungnunga, Chongtu versus State of Bihar on 20th November 2025. And this Supreme Court judgment says that if the court finds that there is a large gap between the first information report and the culminating charge sheet, it is bound to seek an explanation from the investigating agency and satisfy itself to the propriety of the explanation so furnished. And this judgment also says that the investigations cannot continue endlessly. And it shall be on the petitioner or the accused that there should be a liberty to approach the High Court under Section 528 BNSS/482 CRPC seeking an update on the investigation. Or if the doors of the High Court have been knocked by the accused, quashing. So it is highlighted in page number 23 and 24, my lord.
Any time during the investigation, did the magistrate pass any order?
In that
Is
matter,
there
Your
any
Lordship, I
order?
have no idea. And moreover, the appellant did not submit any documents proving that they did not apply. And
Because
This is the first time they
magistrate-
approached the court, and even they
because-
did not approach the CJM court as well regarding the status update.
Yes, my lord, regarding that, since we will never attend that court because the prosecution, the CID, the investigating department, they inform us that to report at their police station, at their station. And at the time of filing this also, we inquired many times about the relevant documents, but they did not allow to furnish such documents in full.
But one thing is that the offense of which they are charged with is violation of that section
21?
21. No,
No, 24,
Immigration
1B.
Act 24,
24,
1B, which is relating to non-possession of valid certificate and permit. So they have already shown that they have the valid permit from
No,
the
Your
district
Lordship,
magistrate.
that permit which they have shown is only a placement permit. And in that permit, they were not allowed to send to overseas. But on revealing the case record, Your Lordship, the accused themselves has admitted that they have sent to overseas, and that is not permitted from their permit. They did not.
But the question is the delay.
Yes.
And Your
2
Lordship,
years,
regarding
6
the
months.
delay, what I would like to submit is that it is a legal position of law that the delay cannot be a factor to quash the FIR. If the FIR clearly noted down the prima facie case against the accused, and if there is a clear prima facie case, delay cannot be a factor. And
So
moreover,
this-
the appellant did not demonstrate what prejudice has been caused to them because of this delaying in FIR. And since they were not behind bars, Your Lordship, they were released on bail from the first instant, and they were not behind bars, and no prejudice have been caused to them. And if such prejudice have been caused to them, they should have seek the up-to-date status. And even that was not done by them.
So that permit which they have shown is not for sending them overseas.
Exactly, Your Lordship. And it is clearly written in the case record, which I have received. And the matter has to be trialed, Your Lordship, to prove their case. And at the stage of quashing FIR, we cannot go into that merit also, Your Lordship. But however, as per the case record, it is very clear that they did not possess a valid license.
And my lord, regarding the delay of that 2 years, 6 months, it caused many prejudice upon us. Those I have mentioned in my petition, para number 8, very clearly.
The prejudice which he had mentioned is that they were feeling shy to go to church. Your Lordship, and they cannot communicate in society as well. So that
And
prejudice cannot
regarding
be
business
cannot
also, like
affect,
education also cannot continue. And so
because
many problems.
their license is only through India, not
No,
outside India.
First of all, in a 482 petition, you have to show that the prima facie that the ingredients of that offense is not present. But in this case, what the learned PP is saying is that the permit or whatever you have shown in your petition is only for within
India.
in placement within India.
No, my
And
lord.
Your Lordship, in the inquiry report itself, it is very
But,
clear.
my lord,
It is
not
mentioning
within
very
India
clear.
only. It is outside Mizoram. Since outside, this permit, this license permits us that to carry on the business even outside Mizoram. Outside Mizoram means even India also, my lord.
Exactly.
India also,
Yeah.
that,
Exactly.
that,
We are saying
that is
India.
okay. But overseas, we are talking about overseas.
And Your Lordship, if the court permits me, in this case diary, Your Lordship, I will read out one portion.
Can you just mark the relevant parts in the CD and then give
Yes,
it?
here it is written that they had admitted that they have sent overseas.
Okay. Any more?
And Your Lordship, in that regard,
Yes.
I would like to place one citation.
Okay.
Incomplete. Let him complete, Your Lordship.
My lord, here I have one citation.
one Supreme Court judgment you have given. This is the Supreme Court judgment which you have given is not specific. It is only on delayed investigation, which is quite general.
Dear Vakil Prasad Singh and Rajasthan State of Bihar on 23rd January 2009. My page number 5, my lord. Starting from para number 15 also.
Page 5.
Page 5, para number 15.
Yes.
It is therefore well settled that the right to speedy trial in all criminal prosecutions is an inalienable right under Article 21 of the Constitution. This right is applicable not only to the actual proceedings in court, but also includes within its sweep the preceding police investigations as well. The right to speedy trial extends equally to all criminal prosecutions and is not confined to any particular category of cases. In every case where the right to speedy trial is alleged to have been infringed, the court has to perform the balancing act upon taking into consideration all the attendant circumstances enumerated above, and determine in each case whether the right to speedy trial has been denied in a given case. Where the court comes to the conclusion that the right to speedy trial of an accused has been infringed, the charges or the conviction, as the case may be quashed unless the court feels that having regard to the nature of offense and other relevant circumstances, quashing of proceedings may not be in the interest of justice. In such a situation, it is open to the court to make an appropriate order as it may deem just and equitable, including fixation of time frame for conclusion of trial. And in para number 16, my lord. Please may continue. Tested on the touchstone of the broad principles enumerated above, we are convinced that in the present case, appellant's constitutional right recognized under Article 21 of the Constitution stands violated. It is manifest from the facts narrated above that, in the first instance, investigations were conducted by an officer who had no jurisdiction to do so, and the appellant cannot be accused of delaying the trial merely because he successfully exercised his right to challenge an illegal investigation. And be that as it may, admittedly, the High Court, by its order dated so and so, had directed the prosecution to complete the investigation within a period of 3 months from the date of the said order, but nothing happened till 27 February 2007, when after receipt of notice in the second petition referred by the appellant complaining about delay in investigation, the Superintendent of Police, Muzaffarpur, directed the Deputy Superintendent of Police to complete the investigation. It was only thereafter that a fresh charge sheet is stated to have been filed on 1st May 2007. It is also pertinent to note that even till the learned counsel for the state is not sure whether the sanction for prosecuting the appellant is required, and if so, whether it has been granted or not. We have no hesitation in holding that at least for the period from 7 December 1990 till 28 February 2007, there is no explanation whatsoever for the delay in investigation. Even the direction issued by the High Court seems to have had no effect on the prosecution, and they slept over the matter for almost 17 years. Nothing could be pointed out by the state, far from being established, to show that the delay in investigation or trial was in any way attributable to the appellant. The prosecution has failed to show any exceptional circumstance which could possibly be taken into consideration for condoning a careless and inordinate delay of more than 2 decades in the investigations and the trial. The said delay cannot in any way be said to be arising from any default on the part of the appellant. Thus, on facts in hand, in our opinion, the stated delay clearly violates the constitutional guarantee of a speedy investigation and trial under Article 21 of the Constitution. We feel that under these circumstances, further continuance of criminal proceedings pending against the appellant in the Court of Special Judge Muzaffarpur is unwarranted, and despite the fact that allegations against him are quite serious, they deserve to be quashed, my lord. These are my submissions.
Okay. Yes.
Yes, Your Lordship. Another point which I would like to submit is that even though the charge section might be a summon case, but however, Your Lordship, it involves social and economic offenses. So it has to be looked into a very serious way. And moreover, it takes time for investigation. And there are...
But did they ever approach the court also for extension of time with any ground, the investigating authority?
For that one,
They
Your
did not
Lordship,
approach, my lord.
I cannot answer that since they did not approach for up-to-date status. Now they were just approaching this honorable court for quashing of FIR. So regarding that, Your Lordship, they did not submit any documents relating that they have inquired about the status. So I cannot answer that, Your Lordship. And since it involves the socio-economic
Social.
offenses, it cannot be taken very lightly. And there are numbers of victims which has to be examined, as well as the accused were also not only one. There were numbers of accused. So it takes time for examination and collection of documents, Your Lordship. So regarding that, the delay, they have reason, and there is no malified intention. And in that regard, Your Lordship, I would like to submit one citation. 2021-19 SCC 401. Paragraph number 5.6.
2021
19
19
SCC 401.
Para
5.6.
yes.
The High Court has no inherent powers to interfere with the investigation unless it is found that the allegations do not disclose the commission of a cognizable offense or the power of investigation is being exercised by the police malified. So, Your Lordship, in this case, there is a clear prima facie case, and even the inquiry report has clearly mentioned the offense. And another point, Your Lordship, that is in paragraph number 12.6.
Twelve point six.
12.6, there is another sub-para 16.
Yes, lastly.
Yes. 12.6, para 16. If I may read out, Your Lordship. Lastly, it is required to be reiterated that while exercising the jurisdiction under Section 482 of the Criminal Procedure Code of quashing an investigation, the court should bear in mind what has been observed in State of Kerala versus O.C. Kutan to the following effect. Having said so, the court gave a note of caution to the effect that the power of quashing the criminal proceedings should be exercised very sparingly with circumspection, and that too in the rarest of rare cases, that the court will not be justified in embarking upon an inquiry as to the reliability or genuineness or otherwise of the allegations made in the FIR or the complainant, and that the extraordinary or inherent power do not confer an arbitrary jurisdiction on the court to act accordingly to its whim or caprice. It is too well settled that the first information report is only an initiation to move the machinery and to investigate into a cognizable offense, and therefore, while exercising the power and deciding whether the investigation itself should be quashed, utmost care should be taken by the court, and at that stage, it is not possible for the court to sift the materials or to weigh the materials and then come to the conclusion one way or the other. In so-and-so, a three-judge bench of this court indicated that the High Court should be loath to interfere at the threshold to the the prosecution exercising its inherent power under Section 482 or under Article 226 and 227 of the Constitution of India, as the case may be, and allow the law to take its own course. The same view was reiterated by yet another three-judge bench of this court in Rashmi Kumar versus Mahesh Kumar Bada, where the court sounded a word of caution and stated that such power should be sparingly and cautiously exercised only when the court is of the opinion that otherwise there will be gross miscarriage of justice. The court has also observed that social stability and other is required to be regulated by proceeding against the offender as it is an offense against society as a whole. And another para is para 13, Your Lordship. Para 13. From the aforesaid decision of the court, right from the decision of the Privy Council in Khwaja Nazir Ahmad, the following principles of law emerge. Police has the statutory right and duty under the relevant position of the Code of Criminal Procedure contained in Chapter 14 of the Code to investigate into cognizable offenses. Court should not rush any investigation into the cognizable offenses. And in 13.4, the power of quashing should be exercised sparingly with circumspection. In the rarest of rare cases, standard in its application for quashing under Section 482 CRPC is not to be confused with the norm which has been formulated in the context of the death penalty as explained previously by this court. While examining an FIR complaint, quashing of which is sought, the court cannot embark upon an inquiry as to the reliability or genuineness or otherwise of the allegation made in the FIR complaint. So, Your Lordship, it is very clear that in the report itself as well as in the case diary, it is very clear that there is a prima facie case against the accused, and quashing of FIR at this stage, there will be clearly injustice for the victim. So my prayer is to dismiss this petition, Your Lordship.
Okay. Heard learned counsel for the petitioner, Mr. Such and Such. Also heard Ms. Felicia learned PP for the state of Mizoram. Chamber disposal, okay, disposed of. And then you send both these and then print out of this one, okay.
Item number 5.
My Lord, I am for respondent number 6. I will not be filing my affidavit.
My lords, all respondents have filed their counter, save and except respondent 6, my lords.
You are seeking time.
No, my Lord, will not be filing.
You will not be filing.
Yes, my Lord.
Okay. Then in that case, we'll list it for hearing.
Yes, my lords, it's a very short point. I have a land, my lords, due to the excavation works done by, my lords, one of the respondents, National Highways Authority. My lords, my entire half of my land has caved in. The state government themselves carried out an estimation of the damage. It came up to around, my lords, approx 50 lakhs. Now we are only seeking that if either you repair my land or you pay us a compensation so that we can, my lords, carry on with our life, my lords. And my lords, it's a 2024 writ. So my lords, we are hoping, my lords, I have taken consent next week, anytime, my lords. That short point, my lords.
Okay, next week for admission hearing.
My lords. 12th, my lords, if we are hoping convenient to your lordships.
Learned counsel for the petitioner, Mr. Jordan Zomung Tanga. So also heard learned additional advocate general, Mr. Samuel.
No, my lord, as a standing counsel for NHIDCL.
Okay. Mr. Don't say additional AG, just say standing counsel for NHIDCL.
Yes, ma'am.
Mr. Samuel, what was your title? Difficult to pronounce. Also heard Miss such and such learned CGC. So it is submitted that the affidavits on behalf of the respondents have been filed. So learned CGC submits that she will not be filing an affidavit in the present case. List the matter for admission hearing on 12/5. Yes.
Obliged.
Item number 6.
May it please Your Lordship, I am appearing on behalf of the state respondents. Your Lordship, I am appearing for respondent number 1 to 5. We are yet to file our affidavit of opposition, Your Lordship, if I may be granted at least 2 weeks' time.
How much time?
2 weeks' time, Your
2
Lordship.
weeks. None appears for the petitioner when the matter is called. Stop. Learned government advocate Ms. Lalun Swami, na? So prays that they may be given 2 weeks' time to receive instructions and to file affidavit on behalf of the state respondents. So prayers allowed list after 2 weeks.
Much obliged, Your Lordship.
Item 7.
Yes, Your Lordship.
Yes, this year has been received.
We haven't received the paper book yet, Your Lordship.
Okay. Has it been prepared? I don't think it's prepared.
I'm not sure, Your Lordship.
This year was received only on 5/5. Learned, the parties are represented by the counsel for the appellant and the learned BP. So, the trial court records have been received on 5/5/2026. So, the registry is directed to prepare the paper book, and thereafter release the matter for hearing after 4 weeks.
Item number 8.
Yes.
Yes.
May I please, Your Lordship, the notice upon the respondent number 2 and 3 is complete.
Awaited.
AD card is received.
It's delivered, isn't it?
Yes.
For both. The office note dated 6/5/2026 indicates that the service on respondent number 2 and 3 has been delivered. Stop. However, none appears for the respondent number 2 and 3 today when the matter is called. Stop. State is also a party. Okay. The respondent number 1 is represented by Ms. Venni Swami, learned government advocate. Stop. Learned counsel for the petitioner, such and such is also present. So should we give them another chance? 2 and 3. Because it was delivered to them only on 15/4.
Yes.
15/4.
My Lord, let them be given
Another time, Your Lordship.
1 week.
1 week.
1 week time. List the matter after 1 week.
Can we have a fixed date? My Lord?
1 minute. After 1 week, awaiting appearance of the respondent number 2 and 3. So list on today's
12th.
Or 14th.
Yes,
14. Yes. 14/5.
Item 9.
Your Lordship, my senior has some personal difficulty if the matter can be taken next week.
Okay. CD will be required. Learned.
No, Your Lordship, in this matter, this is a matter regarding this NDPS Act. And Your Lordship, the grounds which they have raised is a default bail. But however, from the submission which his senior has presented before the last court date, there has been a default bail in her opinion. But however, that grounds has already been decided. So in that case, the case record was called, and even the
before the NDPS court also bail was filed.
2 times.
Okay, on the same ground.
Same ground.
And rejected.
Rejected.
Then unless it's a fresh ground here, the bail application cannot be entertained. Anyway, next, the senior is not there, so. When? Next week?
Next week.
Learned counsel such and such is appearing on behalf of the petitioner, submits that the conducting counsel has some difficulties today and accordingly prays for listing the matter after a week. List next week.
Next week.
Yes. Learned PP such and such is present.
Item 10.
My Lord, as allowed by this honorable court, we have submitted amended course title. However, the office note indicates otherwise. We have marked in the red tag, my lord, in the records, not in the paper book, the original petition that was submitted by the appellant. In the red tag, the second one.
Here?
Yes, yes. There are two red tags. The other one. In the other one, it has reflected that the deceased respondent number 2 has been substituted by his son.
Amended cause title. The amended cause title was for
respondent number 2.
To implead respondent number 2.
No, the respondent number 2 had died.
Oh, okay, okay.
And
substitution.
Yes, substitution was made.
Okay.
As allowed by this honorable court.
Okay.
And we have substituted him.
You have substituted him as respondent 2.
Yes, by his son.
So that is this Shri Byakron Sanga, this one?
Yes.
Okay. So when did you file this amended cause
We
title?
have filed that on 11 March 2026.
So you have to take steps.
We have taken my
No, my lords, I am representing
Okay,
the respondent
you are
1 and 2. So the matter can be listed for hearing, my lords.
Okay, okay. What about records? Records have come.
Everything is ready, my lords.
It's here.
Yes, paper book is there, and
Okay.
Even paper book is there.
Okay. Learned counsel for the appellant submits that he has filed the amended cause title as directed by this court, as allowed by this court on 11/3/2026. Stop. The amended cause title is on record, and the learned counsel, Mr. Such and Such, has entered appearance for the respondent number 2.
1 and 2, my lords.
Respondent number 1 and 2. So the other respondents are also represented. The state is represented by the learned additional AG. And what about Mizoram Rural Bank?
They've already been strike out from the parties, my lord.
Oh, okay, okay. But in the amended cause title, you have still put Mizoram Rural Bank also.
Atira. Strike out.
You should have deleted this Mizoram Rural Bank and chairman, no? Anyway, the matter is otherwise ready for hearing. So please for hearing after 4 weeks. After 4 weeks.
Item 11.
May I please, Your Lordship? Lordship, in this case, the leading counsel for respondent number 1 is down with cold. So if the matter can be kindly taken up next week.
What is this IA for? What? Oh. Learned counsel for the appellant is present. Mr. Such and Such is present. Stop. Learned counsel, Ms. Such and Such, submits that the leading counsel for respondent number 1.
Respondent 2.
Okay, 1 is what?
Is down with cold.
Oh, 1 has some, just say personal difficulties today. Stop. And prays for listing the matter.
Next week.
Next week. Stop. Learned counsel, Mr. Such and Such, is present for respondent number 2. What about 3?
I have taken the consent, Lordship. And
No,
there is
no.
no objection.
Is anyone appearing for 3?
Yes, Lordship. Legal aid counsel.
Okay. The learned counsel for respondent number 2 submits that the consent of the respondent number 3 of the counsel for respondent 3 has also been taken. So accordingly, list the matter next week.
To be applied.
Item 12.
Lordship, although this matter, this regular first appeal has already been admitted, however, Lordship, lower court's records has not been called for yet. So,
Admitted.
Admitted on Lordship on 13/11/2025. The first order.
13. Okay. Learned counsel for the appellant, Ms. Such and Such is present. Stop. Learned counsel, Mr. Such and Such is also present for the respondent. Sole respondent?
Sole respondent.
Sole respondent. Stop. This appeal has been admitted by an order dated 13/11/2025. However, the trial court records have not been called for. Stop. Accordingly, the registry is directed to call for the trial court records and thereafter list the matter after 3 weeks.
After 3 weeks.
After 3 weeks.
Item 13.
My lord, here I was directed to serve notice by way of dusty to the sole respondent, and I have filed my affidavit, dusty affidavit on 8/4/2026, and I believe my landed is representing the sole respondent.
Represented?
Yes, my lord. I'm
Okay.
appearing on behalf of my senior, Mr. Bilaram Enga. And my lord, regarding the IA, which is for condemnation, we will not be filing any objection, my lord.
You do not have objection?
Yes, my lord.
Okay. How many days?
It's 8 days, my lord.
Okay. Learned counsel for the appellant, Mr. Such and Such is present. Stop. This is order in IA 119, okay? Learned counsel submits that the steps have been taken on the sole respondent by Dusty and affidavit has also been filed. Stop. Today, when the matter is called, learned counsel, Ms. Such and Such enters appearance on behalf of the sole respondent and submits that they have no objection with regard to the prayer in the IA for condemnation of delay. Stop. Para. The court has gone through the reasons for the delay set out in the application and find that the sufficient cause has been shown by the applicant. Stop. Accordingly, the application for condemnation of delay of 8 days in filing the connected appeal, connected RFA number 30 of 2025 is hereby condoned and the application stands allowed. Then in the main RFA 30, so your grounds page?
My lord, my grounds is from page 6, my lord.
Okay. Learned counsel for the appellant, Mr. Such and Such. Stop. The instant appeal under Order 41, Rule 1 CPC, read with Section 17, Clause 2, Clause B of the Mizoram Civil Courts Act 2005 has been preferred against the impugned judgment and order dated 22/4/2025 along with decree dated 22/4/2025 passed by the Civil Judge Senior Division Kolasib in money suit number 4 of 2022. Stop. Para. The main grounds taken by the appellant hearing is that the learned trial court had illegally decided issues number 1 and 4 against the appellant/plaintiff and held that cause of action did not arise in favor of the plaintiff at the time of institution of the suit. Stop. Para. Admit the appeal. Call for the trial court records. Stop. Para. Learned counsel, Ms. Such and Such has already entered appearance on behalf of the sole respondent. Hence, no formal notice is called for. However, have you received a copy of the?
Yes, my lord.
Okay. Stop. Accordingly, list the matter after 4 weeks.
Obliged.
Item 14.
My lord, this IA is a condemnation for delay of 162 days, my lord. And the appellant was convicted under Section 22C of the NDLPS Act by the Ladet Special Court, NDNPS Champai, and he was convicted for a period of 10 years and to pay a fine of rupees 1 lakh ID.
Any
6
objection
months.
for the delay?
Your Lordship, no objection.
The instant application under Section 5 of the Limitation Act has been filed by the applicant herein, praying for condonation of delay of 162 days in filing the connected criminal appeal number 7 of 2026 against the judgment and order dated 17/9/2025 and sentence order dated 23/9/2025 passed by the Special Judge NDPS Champai in criminal trial number 57 of 2021. Stop. Para. Heard Learned Counsel for the applicant, she such and such. Stop. The main grounds taken, the main reasons for the delay has been set out at paragraphs 4,
Page number 4, paragraph 4.
5, paragraph 4, 5, 4 to paragraph 4 to 8. No, paragraph 4 to 7. Stop. The court has gone through the reasons and find that sufficient cause has been shown for the delay. Stop. The learned PP, Ms. Mary Kanti, appearing for the government respondent, has also no objection, has also not objected to the condonation application. Stop. Para. Accordingly, the delay of 162 days in filing the connected appeal is condoned and the application stands allowed. Then criminal appeal, in the main criminal appeal. The present appeal under Section 415, Clause 2 of the BNSS has been preferred by the appellant against the impugned judgment and order dated 17/9/25 and sentence order dated 23/9/25 passed by the Special Court NDNPS Act Champai in criminal trial number 57 of 2021. Stop. Para. Third Learned Counsel for the appellant, Mr. Such and Such. Stop. Para. The instant appeal has been preferred on the ground that there has been clear violation of mandatory provisions of the NDPS Act, and that the mandate of Section 57 and 52A, Section 57 and Section 52A of the NDPS Act has also been violated. Stop. Para. Admit the appeal, call for the trial court records. Stop. Para. Learned PP Ms. Mary such and such has entered appearance on behalf of the state respondent, hence no formal notice needs to be issued. List after 4 weeks. Yes.
Highly obliged.
Anyone for hearing?
Your Lordship, with regards to Part 2, item number 9, the matter is handled by my learned friend Mrs. Linda, though my learned friend Victor, appearing for the appellant, is present. If the matter can be listed after 2 weeks.
Okay. What is the matter? POXO or
NDNPS.
NDPS?
Convicted under 21C.
Okay.
Sentence for 10 years.
Learned Counsel, Mr. Victor L. Ralti is present for the appellant. However, it is submitted that the learned PP, Ms. Linda Fambawal, is appearing the matter. He has some personal difficulties today. Accordingly, it is prayed that the matter may be listed after 2 weeks. Yes. After 2 weeks, stop. List after 2 weeks is prayed for. Yes.
Deeply obliged.
Lordship, I seek your Lordship indulgence on mentioning Part 2, item number 4. Maybe this. I'm standing on behalf of my senior, Mr. Joseph Ferrante Amicus, for the appellant. May this matter be listed after a week?
After a week?
Yes, Lordship.
You are mentioning on behalf of?
Joseph.
Okay. Learned Counsel, Mr. Such and Such makes a mention on behalf of the Learned Amicus Curiae for the appellant to list the matter next week. Next week, as the council has some difficulties today. Prayer is allowed list next week. Yes. Send that file.